Yeah.
What are you doing in Boston?
I opened my flower shop.
The headline reads like a dramatic twist. Justin Baldoni is now being sued by the New York Times for at least $150,000, invoking anti-SLAPP protections after his defamation suit was dismissed. But behind those four figures lies a tangled web of aggressive legal maneuvers, power plays, and accusations of media manipulation. Baldoni's defamation case, filed amid his bitter dispute with Blake Lively, was thrown out in June. A judge ruled that the Times reporting was protected by fair report privilege and that Baldoni failed to state a plausible claim of defamation. Now the Times is counterattacking. It's seeking to recoup its legal costs and punish what it calls a meritless lawsuit meant to silence critics. This turn of events suggests the tactics in play were far from accidental. By suing a major news outlet for reporting allegations tied to Lively's complaint, Baldoni's camp risked stepping into anti-SLAPP land, laws designed to protect free speech from being stifled by powerful litigants wielding lawsuits. It all began with Lively's December 2024 complaint to the California Civil Rights Department, in which she alleged sexual harassment by Baldoni during the making of It Ends With Us. The Times then ran a blockbuster article titled, "We Can Bury Anyone Inside a Hollywood Smear Machine," detailing internal texts, emails, and PR strategies that seemed to undercut Baldoni's credibility. Baldoni's lawsuit accused the Times of republishing Lively's self-serving narrative almost verbatim, cherry-picking communications, stripping them of context, and ignoring contradictory evidence. He also alleged the Times gave him insufficient opportunity to respond before publishing. But the courtroom rejected that approach. The judge found that the Times reporting of Lively's public filing was privileged and that Baldoni had failed to allege actual malice or defamation. After the dismissal, the Times turned the tables, filing a separate suit to recoup legal costs and seek damages under New York's anti-SLAPP statute. The lawsuit now asks for both compensatory and punitive damages and specifically cites $150,000 as a floor figure for costs incurred in defending against Baldoni's claims. What emerges is a portrait of high-stakes legal chess. Baldoni's original claims arguably flirted with overreach, suing a press institution for doing journalism tied to public records and exercising free speech. The Times, by invoking anti-SLAPP protections, is signaling that the line was crossed. But that's not the only shade in the story. Baldoni has also alleged that Lively, her team, and even his former PR operator colluded to obtain subpoena power over text messages and communications central to the case, essentially accusing them of legal sleight of hand to gain leverage in this fight. Meanwhile, Lively's lawyers have warned against blame the victim rhetoric, suggesting Baldoni is attempting to rewrite the narrative in court to deflect from her allega.